Okay, I also want to thank Professor Itzu for the organization of the workshop. I'm very happy to be here and to hold my presentation, which will go a little bit in the direction of the French one with regard to private law. And I will deal with ski accidents in both Germany and Switzerland. I want to show actual and legal consequences of ski accidents and try to answer the question whether there is a need for action from a German and Swiss perspective, both from a consumer or from a ski area operator point of view. That's a lot, and because I'm covering two countries, Professor Itzu allowed me to almost double the timing, so be prepared for that. I want to begin with facts and show some ski accident statistics to point out the general significance of the topic. Then I will talk about liability of ski area operators and the legal state of the art concerning ski accidents. Afterwards, I'll briefly talk about collision accidents and liability of skiers. As a last point, I'll analyze the insurance systems in Germany and Switzerland to reveal eventual protection gaps to come to a preliminary conclusion. As regards to statistics, I'll treat the two countries separately and begin with Germany. Unfortunately, there is no central German statistic yet, which covers all German skiers or ski areas. There is a statistic by the German Alpine Club, but this is only based on about 500 reported cases per season. So my main data source is the Foundation for Security in Ski Sports, together with ASU, which is an insurance company. Here, the newest numbers date from season 2013-14. And it is important to know that starting point are German skiers and not German ski areas. Now, as regards the numbers, the total accidents with injuries of German skiers are more than 40,000 per season. But this is only an extrapolation, and there is no reliable data concerning the number of skiers or accident probability relating to ski hours, for example, as it is the case for other countries. Now, here you can see that there has been a significant decline of injuries since the beginning of these evaluations in the last 25 years. Their ski accidents have reduced by more than 58%, which is, of course, a very positive development, maybe because of better slope preparation. However, the number of injuries resulting in stationary treatment shows the seriousness. Sorry? Right. No, all the statistics for Germany regard German skiers, because this is data from the insurance company. Exactly. No, it doesn't. It doesn't allow this conclusion. However, even though there has been a decline, you can see that the number of injuries resulting in stationary treatment shows the seriousness of ski accidents. Around 16%, which means more than 7,000 skiers per season, are treated in hospital after their accident. But also, this risk here has been rather stable or a little bit declining for the last season. Another interesting result is that today around 18% of all accidents with bodily injuries are collision accidents. On the basis of the total numbers from above, one can speak of around 7,000 to 8,000 collision accidents with German as victim. Now, with regard to statistics, I can inform you about an interesting development. In 2011, in Bavaria, a curatorship for alpine security has been founded, following the model of the Austrian curatorship, which probably will be mentioned in the next presentation. And one of its central goals will be to establish a central assessment of ski accidents and security in Germany. Members are, for example, the German Alpine Club, universities, associations of mountain guides, and others, and they also have support from Bavarian ministries. I have contacted them and asked for news, and they replied that the first statistics will probably be published in 2016. So maybe this might be a future stakeholder in this area. Now I would like to show you the statistic situation in Switzerland. Here we can find very detailed statistics which are publicly available. The reason is the Swiss insurance system, which I'll treat at the end. just to be brief, their employees are insured against both occupational and non-occupational accidents, and therefore accident reasons and costs are registered and evaluated each year. Let us have a look at these non-occupational winter sports accidents. Pursuant to these numbers, there are around 50,000 ski and 15,000 snowboard accidents, which means around 65,000 Swiss residents, winter sports persons who suffer from injuries resulting from ski accidents each year. This does not include tour skiing, so only on ski slopes. Contrary to German sources, these statistics show a slight but constant increase in ski accidents from 2000 to 2012, and for snowboard accidents, a slight decrease. So contrary to the assumption made before that snowboarders take more risks. As regards collision accidents, there is the problem that the respective reference points are different. For Switzerland, the accident location is taken into account, but only for collision accidents, whereas for German collision cases, the origin of the insured persons is decisive. Now, according to these statistics in Switzerland, the percentage of collision accidents is around 6% for all snow sports in Switzerland. This number has been quite stable, as you can see. It has fluctuated around 5 to 7%, which means around 4,000 collision accidents. So the German trend of increased collision accidents is not definitely confirmed by Swiss statistics. So we'll continue. The saying, don't trust the statistic you didn't fake yourself, fits perfectly for the next part because I tried to make some comparisons. Of course, this is dangerous. However, I think it is possible to make some general statements. For me, one of the most surprising or even shocking discovery during my research was the proportion between traffic and winter sports accidents. There are around 50,000 police-reported traffic accidents in Switzerland with bodily injuries towards around those 65,000 injured Swiss residents per year. Apparently, the dark number in road traffic accidents is very high, especially for bicycle accidents. But even taking account these unreported cases, one can speak about 82,000 road traffic accidents, including pedestrians, cars, bicycles, motorcycles, and around 80 to 82,000 injured Swiss winter sport residents, injured in winter sports. And of course, I have to add, the large majority of winter sport accidents happens only during a period which is generally not longer than 3 to 4 months, maybe even shorter this year, I don't know, whereas road traffic accidents occur all over the year. In my opinion, this is at least basis for discussion concerning the liability rules, for example. To give you even more figures, I have also compared ski accidents with other sports. Here just a brief overview. First at the left we have injuries per million sports hours. There skiing, snowboarding is not in the front, neither for costs per 1,000 sports hours. There rather ball sports seem to be dangerous and costly. But in my opinion, the relation to sports hours may be not adequate because skiing is an all-day activity. The third chart on the right is the most important for me in terms of society relevance, because it shows the costs per case. Here skiing is in the 4th place with around 7,600 francs per case, which makes a total of around 369 million francs per year. The costliness is confirmed by these charts. With regard to the overall sport accident costs of all persons who were insured in the mandatory accident insurance in the year 2013, more than a third are caused by winter sports, vis-à-vis under 30% for all ball sports. Plus, as you can see on the right side, these costs seem to have increased throughout the last years. So, my conclusion for the first part, facts and figures, is that ski accidents are less frequent, but more dangerous and more expensive than football and other ball sports accidents. The significance of the topic is confirmed by the fact that the numbers of winter sport and road traffic accidents is not significantly different, rather nearly the same. Pursuant to German statistics, there has been a strong increase in collision accidents, which often lead to severe injuries. But unfortunately, it is difficult to compare numbers of Germany and Switzerland because there are no uniform evaluations as regards the total number of regular skiers, total number of accidents, costs and results, and especially the reasons of accidents, whether it was due to a collision or because of a lack of security of the ski slope. And to reveal the real problems in practice, I would also be interested in a number of cases that are decided by the court, because you can only find the published decisions from higher courts, for example. There's another problem of the consumer forum in private international law. I don't have the time to treat it today, but maybe this will be open for discussion, or I'll be definitely treated in my paper. And for a real comparative study whether the level of security differs between European states, we need uniform evaluations. And to compare against the background of eventually different liability or security standards, it would be helpful to have statistics assessing a certain accident location, not a certain nationality of victims. However, after our first discussions and presentations, I have already learned that it might be very difficult to get these numbers from ski area operators. Now we are done with numbers and statistics and can attack the legal chapter. First of all, the statutory sources and liability regimes are not very different between Switzerland and Germany. Therefore, I want to start with similarities and afterwards show some slight differences. Liability claims by injured skiers against ski area operators can be based both on contract and tort law. There is a secondary contractual obligation for ski area operators to maintain security on slopes, as well as in lifts, and provide for eventual rescue services. And there are similar obligations against the background of tort law. For both countries, the relationship between tort and contract law is not an exclusive one. It is rather possible to claim on both legal bases at the same time. One interesting difference is to be mentioned as regards prescription periods. In Germany, this is principally 3 years, both for contractual and tort claims. By contrast, in Switzerland, there is principally only 1 year prescription for tort and 10 years for contractual relationships. Maybe a reform of those prescription rules will lead to a unification and to 3 years prescription for tort as well as for contractual claims, but this reform project is now going on for several years. However, it has not yet been written off, so I can't tell. There is another interesting point in Swiss law, which is the works owner liability. Pursuant to 58 of the Swiss Obligation Code, the owner of a works is liable for a defect in his or her works, which means principally an objective liability. And this is also applicable on ski slopes, but because the criteria for lack of standard of care and defective works are quite similar, in the end there are no material differences between the so-called strict liability and the fault-based liability, which is said explicitly in every decision on ski area operator liability. Now, against the background of the mentioned legal basics, it is crucial to know the scope of safety obligations. For a better illustration and as discussion basis, I want to mention that during my research, I identified mainly 4 types of cases. First, missing protection or cushioning of obstacles or lift piles. There, the outcome mostly depended on the circumstances of the particular case, for example, the place of the obstacle or the steepness of the slope. Then the question whether slope preparation was inadequate. Here, most of the cases, or nearly all of them, were decided in favor of ski area operators. Then I would call them crash fall cases, often very severe, when a skier crashes and as a result falls down a cliff, for example. Here also, the decisions I found were rather in favor of ski area operators, because of the self-responsibility of the skier, who is meant to ski in an adequate speed. And then there are the lift accidents, not with cable cars, but rather at the exit of chair or drag lifts. Here also it depended on the concrete cases. For all these cases, principle and starting point in both jurisdictions, and also this is emphasized in any court decision, it is the personal responsibility of the skier to ski in accordance with personal skills. In Germany, this is the formulation of the courts that only atypical risks or dangers have to be secured by the ski area operator. In my opinion, this works quite well in Germany, opposed to Italy, apparently, because so much depends on the concrete circumstances, the weather, the slope, landscape. There are millions of different types of landscapes. By contrast, typical risks have to be borne by the skier. And in some German decisions, common practice in other countries is taken into account. Then for Swiss courts, the assessment generally is as follows. First, it's the question of specific rules, soft law. This is analyzed. Then eventual common practice is assessed. And then additionally or subsidiary, the circumstances in a particular case are taken into account. And then in both jurisdictions, an assessment is made. It's the question whether the accident could have been prevented by certain security measures. Discretionary assessment is undertaken, taking into account the efficiency of the measure, probability of the danger, the extent of eventual damages, costs and disadvantages, as well, I said it before, the self-responsibility and necessary standard of care of the skier. As I've said before, Swiss courts consider soft law from different sources. In the following, I'll only talk about soft law regarding ski area operators, not behavior of skiers. And in Germany, there's not much soft law in place, especially the DIN, the German Institute for Standardization. There are some rules on signposting, but not very important. By contrast, in Switzerland, there is first the SKUS, Swiss Commission on Accident Prevention on ski pistes, ski slopes, and the SBS, the Cable Car Association. For those who do not know these rules, I've copied the table of contents of they are online, accessible for everyone. Just to show you, they are very detailed, treat nearly everything, the slope marking, slope boundaries, general principles. These are the SKS rules, and SBS, now the SKUS are even more detailed. And accordingly to SBS, also these rules will be updated this year. Now, those norms are a minimal standard. The courts do not have to follow them, but in practice, they mostly do. At the same time, they always mention the possibility to require higher standards, with the result that, in fact, the soft law defines security obligations for ski area operators in Switzerland. In my opinion, this is a big advantage for two reasons. First, ski area operators know which behavior is expected from them, and it's the same for all ski area operators. Therefore, and second, security obligations are adapted to current practice much faster. To illustrate that, I want to give an example of the German Federal Supreme Court decision from '85. We discussed it yesterday and came to the conclusion it is a strange decision, but it's there. The court asserted that there was indeed a breach of a security obligation. It was about the cushioning of lift piles, but that this breach was not to be judged negligent, entailing an obligation to pay damages, because the protection of lift piles was not common practice yet. So even though an obligation had been breached, according to the court, the injured party had to go away empty-handed. 85, yeah. My conclusion for this chapter is that there are no material differences in ski area operator liability. The central question in both jurisdictions is whether there has been a breach of duty with regard to safety obligations. But one main difference is that in Switzerland, much more detailed soft law is in place. But, however, the outcomes of the cases are quite similar, and in my opinion, rather balanced, because the judge always take into account and emphasize the self-responsibility of the skiers, and there is no reversal of the burden of the proof. So the damaged party has to prove everything. Now we are coming to liability of skiers after collision accidents. I will treat this subject only very briefly because Professor Kadner will look into the question in detail and from a comparative perspective. Just want to say, in my opinion, this subject is very relevant for our workshop because the risk of having a collision accident seems to increase. In Spain, it seems even to be the majority of accidents. Maybe because of better protection gear, which invites to go for higher speeds. I also thought that the subjective security sensation would be an important point for the consumer, which is not confirmed by the statistic from Poland. Now, as regards the liability regimes in Germany and Switzerland, there is no special classification for winter sport on ski slopes. In particular, skiing is not classified as dangerous activity. By contrast, normal tort rules apply. In other words, there is fault-based liability, and this fault has to be proven by the damaged party. In both countries, the principles and requirements for the necessary standard of care for skiers are derived from soft law. The FIS rules, which have been treated by our French colleagues, they are clearly recognized in Germany and Switzerland. In Switzerland, additionally, we have some SKUS rules for snowboarders, snowparks. In Germany, there are some rules made by the German Alpine Club. Similar to the liability of ski area operators, violation of these rules does not automatically incur liability, but it is a strong indication. The problem in such cases is rather that often it's very difficult for the damaged party to prove what actually has happened. Therefore, I want to give 3 examples from German case law. One from 2012. There, 2 skiers descended a large slope together. There was a collision. Nobody could prove how it happened exactly. One party suffered a complicated knee injury. Afterwards, he sought compensation more than 200,000 euros, material and immaterial damage, and also a declarative statement that the other skier should be held responsible for future damages. And even though probably both skiers acted careless, pursuant to the judges, it wouldn't have even been helpful to seek an expert opinion. And the result, no damages at all were granted to the injured skier. The next one, 2013, there was a snowboarder and a skier. Pursuant to the snowboarding Clément, the snowboarder, tried to stop when the defendant, the skier, crashed into him. And pursuant to the skier, as she was a slow and unsecure skier, she wanted to cross the slope and the snowboarder crashed into her. And after different expert opinions, the outcome was that, in fact, both descriptions were possible. There was a 50% probability that the claimant was standing, so no clarification of the question who came from above, and there also no damages were granted for the claimant. And then also an old decision, but there I just want to mention that judges of the higher regional court visited the ski slope with the outcome that they said both skiers should have noticed each other. So both of them didn't act with reasonable care. So the fault of both riders there granted to the claimant, but with reduction of 50% because of contributory negligence. But to say this, they had to visit the slope, so very time and cost consuming. There are many other cases in recent German jurisprudence concerning collision accidents, and mostly it is the question what actually has happened. In other words, here we have problems regularly, and this may be a possible field for our workshop. In the last section of my presentation, I want to examine where it is necessary to have a functional liability regime. In other words, what are the damages one eventually has to pay out of his or her own pocket if no other party is held liable, or from a perspective of ski area operators, which may be the costs of an accident resulting from breach of security obligations. For this question, I think it's first necessary to identify the different types of damages. These are the following: the retrieval and rescue costs, treatment, compensation for integrity damages, property damages, loss of earnings, lost earning capacity, costs for care. Now I want to start with Germany. There, a mandatory health insurance is in place. There is no mandatory private liability insurance. However, around 85% of German households do have such a private liability insurance, which means that a considerable 15% of all households do not have such an insurance. The rescue retrieval costs concerning ski accidents, it depends a little bit on the insurance, but these costs may have to be taken over by the injured party in Germany. The costs for treatment are taken over by mandatory health insurance. Nearly all of the population does have some health insurance, so no real protection gaps there. There is no mandatory insurance for the compensation of personal suffering, so this maybe has to be taken over by the injuring party. Same for property damages. And now loss of earnings, they are very important. If the injured person is unable to pursue working for a considerable amount of time, there may be a significant loss of revenue, and I'll explain that on the next slide. Also very important, eventual lost earning capacity, which means if a young person without pension entitlements gets injured and is not able to pursue a certain education, this kind of damage is not taken over by the social security system. And then costs for necessary care of old people. Their German caregiving insurance covers costs only partially, so with standard rates. Now let's come back to loss of earnings. This may look like an advertisement for an insurance company, but this is in fact a situation in Germany. The first 6 weeks, there's a so-called continued remuneration, 100% taken over by the employer. For longer work losses, there are sickness benefits which are taken over by the health insurance, 70% of normal earnings, but their maximum duration is 78 weeks within 3 years for the same injury or illness. And after that, there is no further compensation if no private insurance is in place. This was the situation for employees, and the problem is even more existent for self-employed people. There, everything, in fact, depends on the question whether one has a private insurance. Now, for Switzerland, there is also a mandatory health insurance and an accident insurance for employees. As I mentioned in the beginning, this accident insurance is very broad and takes over the costs resulting from both occupational and non-occupational accidents. But young persons, self-employed, housemen, housewomen are not in this accident insurance system. They have protection via the health system, but this does not cover loss of earnings. So in general, the outcome is the same as in Germany. Rescue retrieval costs depends on the case and insurance. With regard to integrity damages, these may be taken over by the accident insurance. So if you lose an arm or something else, this may be compensated. And the most important protection gaps are with regard to loss of earnings. Employees who are in the accident insurance get a daily benefit which is 80% of normal earnings to the maximum of more than 100,000 francs per year. So for employees, the situation is quite good. Contrary to Germany, this sickness benefit is paid until the pension or death. However, for persons who are not insured as employees, loss of earnings are principally not covered. There is the possibility to conclude such an additional insurance. If not, there's just some basic pension, invalidity pension, but this amount is also quite low. So my conclusion for this chapter is there are possible protection gaps for consumers if no person is found to be liable. And in Germany, it's especially the case for compensation for personal suffering, long-term loss of earnings, future loss of earnings, and possibly caregiving expenses. A little bit the same for Switzerland, with the difference that loss of earnings are taken over for employees. There the situation is not that bad. So in summary, we have looked into numbers of ski accidents, liability of ski area operators, as well as the liability of skiers, and had an overview over the insurance system. Thereafter, my results are that there are similarities regarding the scope of security obligations for ski area operators in general. There are differences concerning security evaluation and statistics. There's much more detailed soft law in Switzerland, which in my opinion could serve as a general model because it offers both flexibility and legal certainty. As regards Germany and Switzerland, the most urgent need for eventual further action, in my opinion, is to gather more reliable data. With the present statistics and cases, justice and protection gaps, in my opinion, are most likely in the field of collision accidents. Now, I'm looking forward to the further contributions and to discussions with all of you. Thank you very much.
Thank you very much, Hannes Meile, for this very clear and informative presentation. Due to our little break, I didn't have the opportunity to introduce him. Had I had the opportunity, I would, among other very good things about you, I would certainly have mentioned that he has acted as a snowboard instructor. So he knows what... He's probably an interested party. I would rather put it, he knows what he's speaking about. So we come now to our last presentation for this morning. I pass the floor to Andrea Schweighofer. She is teaching and doing research at the University of Innsbruck in Austria.
Hello, dear colleagues. So, first of all, I have to thank you. Oh, shall I take this one? Hello? Okay. So, hello again. I want to thank you, Professor Itzo, for being here. It's really a pleasure. So, from my side on, I'll give you an overview of the economic and law situation in Austria. I would like to start by telling how important tourism is for Austria based on some numbers and statistics. Second, I want to explain how monitoring a ski area is managed in Austria. After that, we will turn our attention to the general legal basis of ski law and finally to the questions of liability concerning safety measures. In this regard, I'll only focus on the liability of ski area operators. I'll end with a short summary. So let's start with some facts. Every third euro in Tyrol is being earned directly or indirectly to the tourism sector, and every third full-time job in Tyrol depends directly on tourism. More than 8 million people regularly ski in Austria every year. In the winter season 2012-2013, businesses sold 50 million day passes for skiing. The downside of the sport's popularity is, of course, the number of accidents that occur on the slopes. Moreover, 7,325 people of 26 ski areas reported injuries in the winter season 2012 and 2013, of which 80% were skiers, just 14% snowboarders, and 6% others. More than 90% of the injured men and women were wearing a ski helm. Considering the high number of people participating in winter sports, the injury rate for skiing is very low. So just 1.43 injured persons per 1,000 skiing days, which equates to one injury in about 50 years practicing skiing at an average of 14 skiing days. The rate of injury on ski runs has decreased by more than 50% in the last 10 years, and it is still declining in Austria. Costs that occur for the SAOs due to the compliance with safety formalities are the major part of the whole costs a ski area has to bear. There does exist subsidy for ski areas, but it is up to the operating company to decide how the given money will be used, as there are no specifications on how much money from grants or other financial sources must be spent on the safety sector on slopes. For example, a helicopter rescue service costs about 4,000 euro, while a mountain rescue without helicopters costs 1,000 euro. Both will not be reimbursed by the statutory health insurance. Insured persons bear the costs themselves, so just in private. It is common for ski area operators to have a voluntary liability insurance in Austria. As a result, all costs that occur from all kinds of damages or loss are completely covered under the insurance. During the past few years, the insurance rate even decreased. There are several personal insurance options for individual skiers. An inexpensive additional insurance, for example, is offered by several clubs like Alpenverein, Naturfreunde. Also, owners of a credit card have an included insurance, for example, MasterCard, Visa. Also, the very popular season cards for ski regions, such as the Snowcard Tirol, Freizeitticket, if anyone knows, have an included insurance. Leisure accidents of domestic skiers are predominantly covered by their household insurance. There is opposition to creating a system that would obligate hobby athletes to get compulsory liability insurance in Austria. Moreover, I think it would be also impossible and impractical to check whether every skier on the ski run has insurance. So it's not very practical. To reach the widest possible target audience, many ski areas advertise that they have a variety of slopes, including sections with powder snow or even more adventurous routes that stray from the regular runs. This modern image is especially meant to attract the attention of the younger generation. Due to the growing competition in the ski industry, ski area operators are under pressure to provide an increasing number of services to guests, such as fun parks or night skiing. Marked correctly, these new services translate into more clients and, of course, larger profits. A random sample of 9 ski regions, as you can see here, including the 5 glaciers of Tyrol, shows that all of them have already incorporated the possibilities of freeride slopes in their marketing strategies, as you can see in the topic freeride advertisements. I have looked on the websites of these ski areas. I took the 5 glaciers and 4 other ski areas. For example, the one Axemalizum is a very small one, but close to Innsbruck. Every one of them was advertising free riding, but only a few of them had safety instructions. Just the 3 of them, namely the Pitztaler Gletscher, the Kaunertaler Gletscher, and the Stubaier Gletscher, explained that the skier that the skier is driving completely at his own risk and that safety cannot be guaranteed. In my opinion, safety of ski areas isn't topic of advertisements. None of the ski areas were advertising with safe slopes. This seems to be assumed. Of course, bad publicity spread through media isn't good for the skiing tourism as well. There is no legal obligation in Austria to install surveillance of slopes, but as you can see, this is voluntarily set up by the ski area operators everywhere, which is also standard in Austria. You can see it on the topic with the rescue service. Also, the prices, I think, do not differ considering the varying sizes of the ski areas. This leads me to the next point, how monitoring a ski area is managed in Austria. In practice, however, it can be expected that this gets done by the staff of the SAOs. On the one hand, they check the maintenance of safety standards daily on and outside the slopes, and on the other hand, they are monitoring if skiers behave in compliance with safety instructions. A special police based on law would be a special police regulatory action, and this would fall under the federal state competence authority. So far, only the federal state of Vorarlberg has implemented such a police regulation. The service and lift staff of the ski area operators is fulfilling the same task as ski patrollers. In turn, the regulation by law of installing actual and law ski patrollers seems to be obsolete to me. The next issue I want to talk about is the legal basis for ski law in Austria. The traffic on slopes is not regulated by law in Austria. Claims for damages out of ski accidents are basically subject to the general rules of tort law. There are mainly two fields in civil law that come into question as a legal basis of safety obligations on slopes. Firstly, a contractual liability in connection with the contract of carriage that is set up when the skier buys a ski ticket. And secondly, a tortious liability, the so-called Wegehalterhaftung, waykeeper liability. Addition to these two, there is also an absolute liability concerning the use of dangerous machines, which is a non-fault liability, but I will exclude that. Let me explain the characteristics of contractual liability. Generally, the contractual liability is the most practicable for each skier or winter athlete, as it establishes a reversal of the burden of proof after paragraph 1298 ABGB, the General Civil Law Code, as well as a liability for only slight negligence. Concerning liability under contract assistance, for example, the staff of the skiway operators, the security personnel, are extensively assigned to the SAO. He is responsible for every error committed by an assistant in his line of work. As a result, the winter athlete is in an advantageous legal position when it comes to court procedure because of an accident on the slope. Turning to tortious liability. As I have said, we have the so-called Wegehalterhaftung in Austria, when there exists no contract between the ski area operator and the skier. Paragraph 1319a ABGB limits liability for damage caused by intentional or by gross negligence, so the SAO is not liable for a slight degree of negligence. Ski area operators as waykeepers are just liable for their assistance in very restricted cases, namely when they employed an incompetent person or are aware that the person could be dangerous. There is also no reversal of the burden of proof according to paragraph 1298 ABGB. Irrespective of the ski area operator safety obligation, either because of a contract of carriage or because of a tortious liability, under paragraph 1319a ABGB, the principle of ingerence, or in German Ingerenzprinzip, can create a liability for the ski area operator if the business owner has caused any danger without providing safety. It often happens that damages are not only caused by a failure of diligence on the part of the ski area operator, but also because an insufficient care of the skier. In such cases, the skier must accept a contributory fault and subsequently be prepared to accept that he is jointly responsible for the damage. Compensatory damages are reduced by the extent of a contributory fault. The FIS rules, or POE rules, which were written under the Austrian Board of Trustees for Alpine Safety, it's the one Hannes recommended, they are mainly following the FIS rules. These are not legal rules in Austria. They're just forces that regulate traffic, which should provide accident prevention measures and ensure correct ski activity on the slopes. But still, the FIS rules are recognized as being extremely important in Austria, especially as they give a summary of all due diligence obligations which must be suspected in the interest of all participants of alpine ski sports. Each winter athlete is expected to be familiar with the FIS rules. Besides the POE rules and the FIS rules, the Austrian Board of Trustees for Alpine Safety established special recommendations for ski tourers as well that mainly follow the FIS rules, but are complemented with special features that only concern the field of ski touring. In the context of safety obligations, the ski area operator and his staff is obliged and authorized to intervene and take active steps to stop anonymous behavior on ski runs, and in order to prevent danger that occurs for other skiers. If a winter athlete disregards the guidelines of winter sport to such an extent that his behavior results to an atypical danger for others, the ski area operator is therefore authorized to declare not only a formal warning, but also to completely exclude the winter athlete from carriage. Taking the ski pass away. Coming to the next part of my presentation, and also the last one, measures concerning safety, first on ski runs. The safety obligations of the ski area operators are at least limited to the opening hours of the ski lifts, as we have heard in the morning. Only during this time, the ski area operator has to ensure the proper maintenance and repair of the slopes and the safety of the passengers. The main aspects concerning the obligation to provide safety on slopes can be divided into two fields. First, the demarcation of the boundaries of the slope. In general, the safety obligations of the ski area operators end at the boundary of a slope. The ski area operator is obliged to mark these boundaries. That includes also a 2-meter area outside the actual slope as a buffer zone in case of unintentional falls. It has to be obvious for the winter athletes where the slope and the ski area operator safety obligations end. The presence of non-prepared snow is not enough for an effective marking. And second, to provide safety from avalanches and other dangers. Any warning has to be easily linked and identified to the obstacle. Also, a general hint does not serve the duty of giving information. In the case of non-removable dangers, the ski area operator is able to close one slope or at least block a certain part of it. These barriers cannot be understood as legally binding restrictions, as the ski area operator in Austria cannot prevent people from using the area. This is a public right. Slope users still have the freedom to enter this zone. But as soon as the ski area operator imposes a barrier, this part of the slope automatically loses its legal dedication as a slope. Winter athletes who ignore these barriers and drive down the locked parts move illegally and unlawfully. As a result, the ski area operator is released from liability. Coming to the off-trail part. In this case, the skiers descend hillsides that are neither prepared slopes nor secured routes for ski tours. Therefore, these athletes do not fall under the slope safety obligations of the ski area operator. Freeriders move completely at their own risk. There is no obligation for the ski area operator to secure the free skiing area. The only situation that extends safety obligations beyond the regular slopes arises when the off-trail slopes cannot easily be distinguished from the normal slopes. That means concretely, if a diligent and responsible skier is not able to discern the actual boundary of the slope, all occurring accidents have to be analyzed under the purview of slope safety obligations. Very often, this occurs because the edge of the slopes is an intensely trafficked area, as we all know. Consequently, skiers get the impression that these trails still belong to the secured slope. Hence, this transitional area inherits an implied dedication as a slope. Therefore, even a diligent and consecrated skier cannot see the difference between the regular and the unregulated slope because of the given circumstances or snow conditions. Of course, local and special circumstances must be considered when assessing what will be dedicated and organized slope. Similarly, a responsible skier cannot think that he is moving on a regulated piste when he is surrounded by trees and rocks and other obvious characteristics of free ski area. I want to say a few things about tours too, but I keep it short. Normally, the tourer does not enter into a contract with the ski area operator in Austria as he is not reliant on the ski lifts and gondolas. But for example, a contract-based relation begins when the tourer takes a parking ticket because the ski area operator can imagine that the customer only uses the parking area to make a tour in this area. The same rules apply for tourers who possess a seasonal ticket as they are equated with ordinary skiers. Although this is not tradition in Austria, there is also the possibility for tourists to pay remuneration to the ski area operators. The safety obligations of the ski area operators are at least limited to the opening hours. If a ski area operator provides his slope to tours once a week during the evening, this does not affect its safety obligations because the ski lift is not operating during this time. The same principle applies to touring outside the season or outside the official slopes after regular business hours. So I'd like to sum up with the following points. It is beyond controversy that high safety standards are required of the ski area operators that cannot always be fully provided in practice, also because of the very high level of diligence they actually have to fulfill. Costs that occur from all kinds of damages or loss are completely covered under insurance. The High Court of Austria in civil matters also considers contributory fault. Ski area operators in Austria are generally pleased with the current law situation and clearly declare themselves in favor of minimizing the laws affecting skiing and other alpine sports. So this is the end. Thank you for listening. And
thank you, Andrea Schweikhofer, for your very clear and informative presentation. I think we are at the end of this morning session.